Um, I will
This is being recorded.
I will introduce Bernie Rhodes. Well, I don't think he needs introduction, but I'll I'll go for it anyway. But Bernie is a terrific First Amendment attorney who represents a lot of media outlets in Kansas City and around the country too, I believe. He works with us at the Midwest Newsroom, and I think he's the best in the business. He is in my experience working with him here and in earlier stops in my career, he is the type of uh, lawyer who wants to figure out how a journalist can best tell a story rather than looking for ways to water things down. And so he's going to cover a range of issues for us today. And as you go along, just a couple notes for everybody. Introduce yourselves in the chat as you, if you're in on this. And if you have questions, I'm going to be keeping an eye out on the chat. But the way I typically like to do things, and Bernie and I talked a little bit about this morning, is if he's kind of going along and you have a question, feel free to raise your hand, and I'll try to keep track of everybody and moderate that. And we'll have time for questions too at the end for anything that hasn't been covered, but I don't want to waste a lot of Bernie's time. And so I'm going to turn it over to him to get started. Bernie, thank you for doing this, and thanks for being here.
Thanks for inviting me. It's important that we all move the ball forward here in this age of disinformation. Public radio in particular is a source of objective truth, and we need to foster that effort at every step. I want to try to do three things with you today. I want to talk, first of all, how to gather the news without getting sued, how to report the news without getting sued, and perhaps most importantly, what to do after you've gathered and reported the news without being sued. To start with, the reason we're doing this is it's important to understand the First Amendment does not give you a license to break the law. We may think the First Amendment is great, which it is. We may think the First Amendment gives us some available defenses in a lawsuit, which it does, but it does not give us a license to break the law. So in order to avoid breaking the law, we have to know what the law is. And so that's part of what we're going to talk about. So for example, if I want to know what the response time is for the local fire department, because I have heard that there's union problems and the response time is slow, I can't set a vacant house on fire and then clock to see how long it takes to get there. That's breaking the law. It's a noble purpose. We may be exposing these union problems at the fire department, but that's clearly not allowed because we don't have a license to break the law. The same thing on, that seems like an absurd characterization. By the way, it's not absurd. I've had many reporters suggest doing something very similar to that. But under the NPR Code of Ethics, and by the way, I'm not here to talk to you about the Code of Ethics. That is entirely separate. I know it does not surprise you that legal and ethics are two different things. Most people think lawyers don't have their own ethics, but that's a different issue for a different topic. But under the NPR Code of Ethics, you can do undercover reporting in very limited circumstances. So I'm not here to suggest that you should start doing undercover reporting. I'm here to suggest to you that if you have otherwise met the requirements of the Code of Ethics, and you want to do undercover reporting, what did I just say? You can't break the law. One of the laws is fraud. You can't lie. So if you're filling out an application, and for example, it needs your place of employment, you don't have to list KCUR. You cannot list Walmart because you're not employed by Walmart. But if you just think about it hard enough, you could list the University of blank. That's true, isn't it? You could list vaguely the curators. No one knows what that means. So as Steve said, My job is to help you get the story, not to tell you what that, oh, forget it, you got to go away. So you have to be creative in coming up with solutions that comply with the law. And misrepresentation is a classic example. If any of you ever remember from your journalism law class, a case called Food Lion. That was a case in which ABC News went undercover at the Food Lion chain of grocery stores because they wanted to expose unsafe, unsanitary food handling practices, a noble venture. But in the job application that one of the producers submitted, she completely lied about her history, completely made up her history of working at different various grocery stores. And in my favorite, said, I just love to wrap meat. Again, sounds interesting, and she got the job, but all of those are clearly lies, and we don't lie. That's called fraud in my business, because in my business, you have to have a longer word for everything that in English there's a short word for. You would call it a lie. I would call it fraud in my business, and we don't engage in that. The same thing under the NPR Code of Ethics, you are not supposed to record a conversation without getting the other party's consent. That's an ethical rule. That's not a legal rule. The legal rule is, like everything, complicated. In most states, if, for example, in Missouri, Kansas, Nebraska, Iowa, we have what we call one-party consent. As long as one party to the recording is consenting, and if you're making the recording, by definition, you're consenting, then it's legal. Other states, most notably California, are what we call two-party consent states. So both parties to the conversation have to record. So as a result, nowadays, particularly with cell phones and phone numbers, you have no idea where anyone is calling from. So you may well be violating a two-party consent law by having a conversation with someone, even though the area code might be that you're speaking to St. Louis. The person might be in California. So again, what's the answer? There is no easy answer. These are things to think about. Things to think about, do I really need to record this conversation? And in regards to needing to record the conversation, you also have to consider, since we are radio, there's what's called the FCC broadcasting rule. It is the dumbest thing in the world, and I hate it, but I deal with it every day. It's the FCC broadcasting rule says that you cannot record a telephone call. This is not in person. This is a telephone call for broadcast without first telling the person on the other end of the line that you're recording it for broadcast. The rule was designed for those crazy morning radio shock jocks who call people up and, get them to say dumb, embarrassing things, as they first wake up in the morning, and then put them on the air. However, the FCC has repeatedly ruled that it applies to traditional news gathering activities. Now, again, that's not a law per se, it's an FCC rule, and it only applies to broadcast. So you could, for example, record someone's conversation, assuming you've got by the two-party consent issue, assuming you've got past the NPR Code of Ethics, and you could post it online as part of your report, because the FCC rule only governs on air, radio and television. Again, there's a lot. I don't expect everybody to remember virtually anything of what I say today in terms of the answers. It's issue awareness I want you to be thinking of. When you begin considering this type of news gathering, to know, well, I remember there's something about that. In that case, go to whoever your editor is. They'll eventually make their way to me or somebody like me, and we can help guide you. Again, our job is to get you to X, not to tell you can't go to X. Similarly, we've all heard, and many of us have engaged in what we typically call police ride-alongs. That's great. The police can invite you to ride along, but the police have no authority over private property. Even if you have permission to ride along with the police, or if you show up at a crime scene and the police are there, the police could not invite you onto private property. They have no basis to do that. If you go onto private property, you are committing trespass. Sorry, I forgot. I knew I needed to do this. You're committing what we call trespass. You're going onto someone's private property without permission. The police don't, I mean, let's say the police show up at my house. Let's say I fall over here while talking to you, and my wife calls 911, and the police and the fire and the ambulance show up, and you happen to walk by. You can't walk in my house. I mean, just think about it. That's common sense. But we assume if the police are there, they can invite us in. No, they can't invite us in. While we're on the topic of police, it's always a difficult relationship between the press and the media. If you're at a crime scene, the police can control the scene. That does not mean they can tell you to stop recording. They absolutely cannot tell you to stop recording. It is clear under virtually every state law at this point, you have a right to record the police so long as you are not obstructing their activities. That clearly means, for example, if you're across the street, if you're out of the immediate danger zone, you have the right to record the police. And if they tell you to stop, first of all, I mean, use some common sense, folks. Be polite. Don't call them pigs. Don't swear at them. Advise them that you're a member of the media and that you have a First Amendment right to record them. It can get testy. I've been there. We did an undercover operation with a client one time. We simply wanted to know what happens if you went into a police station and said, I want to make a complaint about an officer. Believe it or not, it ended up with our reporter being thrown against a glass wall, getting a huge knot on his head, and taken to the hospital. So the police do not like the media. Let's just start with that premise. So we have to be careful about how we deal with them, but we need to stand our ground. I've had reporters arrested at the scene for refusing to stop recording. I'm happy to defend those people. I'm not happy to defend reporters who get belligerent, who get obnoxious, who get in the face of the officer and truly obstruct what's going on. That's a crime. And again, we don't have a First Amendment license to violate the law. This could go to extreme. Several years ago, we had a situation here. I happen to be in Kansas City, by the way. We had a situation in which a young child was missing. It was a very high profile case. And the FBI was in, and the FBI literally issued what's called a TFR. They went to the FAA and obtained a temporary flight restriction to keep the television station helicopters out of the area. And when we pushed back, we said, why? They said, well, because we don't want pictures of our dogs searching the area. I knew that FBI agents are called special agents. I didn't know the dogs had their own publicity agents. Until we could get the TFR listed, I advise my clients don't fly into the restricted airspace. We can't break the law. Come to me, we can work with them, we can try to get something accomplished, but we don't break the law. On the issue of trespass, let's say you're doing a story on me, and my office I happen to be at home, as you can apparently probably see, but let's say you come to my office. Well, first of all, let's say you come to my home. I don't have a no trespassing sign. I don't have a no solicitor sign. So you can clearly walk up to my door. You can clearly knock on my front door. You can ring the doorbell. You can have a camera, your phone, a regular camera, whatever. You can be rolling the whole time. When I come to the door, you cannot walk into my house and start walking around. And if I don't answer the door, you can't open the door and walk in. But you can clearly go to the door. You can film your confrontation with me at the front door. You've not trespassed. You've entered the area we call the curtilage, the area immediately outside the house, but you've not gone beyond where you have permission to be. Related to the issue of trespass is one of the 4 variations of invasion of privacy. You've all heard of defamation, of course. That's what we call a tort, T-O-R-T, as distinguished from a tart, something you get at the bakery. A tort is simply a civil wrong. It's something that you can sue and get money for. If you crash into me at the intersection, I'm going to sue you for negligence. That's a tort. It's just a fancy term for a civil cause of action to sue someone for damages. In addition to defamation, we have something called invasion of privacy. That's a separate tort. There are 4 variants, because everyone has a variant now that we have COVID, we have variants. There are 4 variants of invasion of privacy, one of which is called intrusion upon seclusion. It's very similar to trespass. And what it says is if I've intruded into your privacy. So in my case, let's go back to the example. You show up at my front door and I go back to my bedroom because I don't want you to get any video of me. I don't want you to take a still picture of me. I go back to my bedroom and you go to the house next door claiming to be a furnace repair guy. First of all, you've misrepresented yourself, so you can't do that. But let's say you do and you get in. You can't go to their 2nd story bedroom and take a picture of me in my bedroom because you've intruded into my privacy. I've clearly demonstrated that I want privacy, that I don't want to talk to you. That's intrusion upon seclusion. That's an invasion of privacy. Now let's say I'm at my office. You can clearly go to the lobby of the building. You can clearly ask where I am. You can take the elevator up to the 22nd floor. You can, again, rolling with the camera. You can go to the reception desk. You can ask for me. You can film the whole thing. You don't have to say what you're doing. Again, legally, the NPR Code of Ethics is different, and you'd have to get permission, to proceed that way. But legally, you've not intruded upon my privacy. You haven't trespassed because you're entitled to be there. What you can't do is get on the elevator with somebody going to my floor, which is a different floor from reception, and what we call tailgate, get off the elevator with them onto my floor when you haven't been invited there. To get onto my floor, you have to have a key fob. And you can't tailgate. You can't follow somebody onto my floor when they use their fob and you get off, because you're not entitled to be there. That's the purpose of the fob. And so that would then be intruding upon my seclusion, intruding upon my privacy. You've exceeded the authority you have to be there. You clearly have the right to walk into Walmart or a shopping mall. Shopping malls are very interesting. We think of shopping malls as a public forum. You clearly have the right to walk into a shopping mall, to go in, to park at the parking lot, to walk into the mall, to walk into a store, but you don't have the right to go into the back room of the store. There's a fascinating case, happens to be involving a diner, in which this is a TV station, and how TV stations often do the old health inspection stories. These restaurants failed their health inspection. So a reporter went into a diner, wanted to go into the back of the diner, asked we would call him a cook, not a chef, since it's a diner, if he could come back, and the cook said, sure. He shot footage. Before the story aired, the owner contacted the station and said, the cook job duties are to cook. The cook has no legal authority to allow people into the kitchen. The station said, I don't care, I got permission, and ran it, got sued, and the court said, well, of course cooks do not have permission to do that. You were told before you aired it that he did not have permission. That was trespass. There's no First Amendment right to break the law. As a result, case proceeded. So those are some of the physical ways in which we gather news. There's also the personal ways. You have sources. What can we tell a source? What can we promise a source? Well, it depends on how far you're willing and how long you're willing to stay in jail. Each state has some form of a reporter's privilege, a shield law, we sometimes call them. Some of them are what we call statutory, written by the legislature. Some are created by the courts. None of them are absolute. Almost all of them have what we call a qualified privilege that requires the person seeking your information to establish that, one, they can't find it anywhere else. You're the only person who knows this, at least that they're aware of, that it's critical to the case. This is not just some irrelevant fact that they're just curious about. And it won't disrupt future news gathering activities, whatever the heck that means. Clearly, a confidential source is entitled to more protection than just normal, you're calling me up for comment. The problem is, first of all, it's qualified. It's not absolute. So if you make an absolute promise to a source, you're never going to reveal their name. You better be prepared to sit in jail when the judge orders you to do it under threat of contempt. Second, and what's the bigger problem we see nowadays, and this is one of many reasons people hate lawyers. A state, even if you're in a state that has a statutory privilege, the federal courts ignore that. So if you get a subpoena in a federal case, even if you're in Nebraska, which has a good shield law, if you get a subpoena in a federal case, you've got no choice but to comply, because the federal courts don't recognize state law privileges. Now, and we see more and more federal courts rejecting the idea of any sort of a privilege, qualified or not. We don't have the Supreme Court weighing in, but looking what the Supreme Court's doing, I'm not very, very optimistic about it. The Supreme Court is very odd. It's what we in my business call libertarian. And so it protects free speech to the extent of, several years ago, it ruled that, and I didn't even know there was such a thing, pornography that consists of women in high heels stomping on animals and killing them, that's protected by the First Amendment. I'm not sure I quite understand what the social value of that is, but whatever. That's how extreme they are in protection of free speech. But I don't see them reaching out in these areas of privilege, which are not grounded in the First Amendment and don't have those same rights. I would be very careful, therefore, in what I promise people. What you clearly can promise people is, I will do what I can to not have to disclose your name. I won't use your name. You can agree on how you'll describe your source. And as I say, agree on, there's this entire issue of, what does off the record mean? What does background mean? You think you know what it means. I think I know what it means. You and I, first of all, probably disagree. And I guarantee you your source disagrees with what you think it means. I can't tell you how many times I've dealt with a source who believes that they were burned by the reporter. And I can assure them the reporter didn't do it intentionally. It came from a misunderstanding of what the terms of their relationship was. There's nothing wrong with spelling it out in detail and getting the source to agree to that. I mean, again, we can't lie to the source. We can't promise the source we'll never disclose them and then go disclose them. There's a famous case, Cowles versus Cohen Media, in which the reporter promised the source confidentiality. And then for newsworthy purposes, the reporter and its station felt that it was important to go ahead and reveal the source because the source had lied to them. The source sued for what we call breach of contract. I had a promise. You promised me you would not disclose me. You disclosed me. I don't care what your purpose was. You breached your promise. Excuse me. The source sued for breach of contract won. It's no different than any other contract. You agree to paint my house. You don't show up. I got to pay somebody else twice as much. I sue you for breach of contract. We have no right to break the law. A promise is a promise, and it's enforceable in a breach of contract. Let's say that you receive a subpoena from the federal government or the local police. Those are serious. We need to deal with those. Fortunately, while there's no federal privilege, reporter's privilege, the United States Department of Justice has some very good guidelines that prohibit U.S. attorneys and the FBI from aggressively pursuing subpoenas unless it's truly necessary. There's also something called the Personal Privacy Protection Act, which has nothing to do with personal privacy. It's one of those great legal things in which the name means absolutely nothing. What it says is that the police, that includes the local police, not just it's a federal law, but it applies to the local police, the state police, the county sheriff, the FBI, can't search your newsroom unless they jump through all kinds of hoops and have all kinds of extenuating circumstances. So, if the cops show up at your door, literally show up at your door, either at home or at the station, you object. You're polite, but you object. You tell them you want to call a lawyer, you want to stall, you want to record the thing and tell them you're recording, because they may well be violating the law, because I guarantee you 99% of all police officers have never heard of this, nor would they, because even if they had, it's called the Personal Privacy Protection Act. And it only applies to news media. Why it's called that, I have no idea. You want to get information and you get pushback on what's called HIPAA. I mean, we get it every day. I will tell you that the same 99% of police officers who don't know about the Personal Privacy Protection Act, 99% of the time when you get HIPAA, that's not true. HIPAA is very, very narrow. HIPAA stands for I can't get it all right, the HIPAA, Health Insurance Portability Protection Act, something similar to that. The key word there is insurance. HIPAA was designed to and serves to facilitate the electronic submission of insurance claims. That's the I in HIPAA, is insurance. So it only applies to what are called covered entities. People who bill insurance, medical providers who bill insurance agencies via electronics. So your doctor is covered by HIPAA. Your dentist is probably covered by HIPAA, because even though you might not have insurance, he or she undoubtedly has other patients who do have insurance, and they undoubtedly bill electronically. The public ambulance service in your community probably is covered by HIPAA because they submit insurance. The police department, absolutely not. 100%, okay, 99%, no. The police, just think about it. The police department are never going to bill you for medical care. And they're never going to submit that bill to the insurance company electronically. So whenever the police department cite HIPAA, call BS. Whenever a private company, I don't know why I'm picking on Walmart, haven't been to Walmart in a long time. If Walmart says we can't give you information because of HIPAA, call BS. Well, okay, forget Walmart because they have a pharmacy, so maybe they do. Let's go with Dick's Sporting Goods. They don't provide any kind of medical care whatsoever. So that's not covered by HIPAA. We get that all the time, and it's completely bogus. So those are some of the highlights on gathering the news. there's a lot more we could talk about, but we only have limited time, and I want to cover 3 topics, and I've got an hour and a half, so we're halfway in.
Hey, Bernie, if I can interrupt you for a quick second.
Yeah.
We had a question here asking, how literal is the 2-party consent law in various states? So if I'm on a call with dozens of people, do they all need to consent?
Yes, correct. If
Everybody
one of those people
participating?
got a 2-party consent, they all need to consent.
Okay.
Yeah.
We also have a question from Blaze in the chat, I think.
Yes, hypothetical question. I cover foster care and a lot of court documents are confidential. Sources might offer to get those confidential documents and give them to me. They might say, I don't have that now, but do you want me to get it for you? I know journalists can be given confidential documents, but I don't know if this counts the same. How should I respond to them?
Excellent question. Thank you. I'm going to make a note and include that here. So first of all, there's a case decided by the United States, the old Supreme Court, not the current one, called Barnicki. As long as you aren't breaking the law, what did I say? You can't break the law. As long as you're not breaking the law, someone gives you documents and they broke the law, you're free to use them. That in that particular case, there was an illegal tape recording of a call, 2-party consent. The recording got given to the reporter. The reporter used it. The reporter got sued, and the court said, no, as long as you didn't break the law making the recording, you can use it. In your hypothetical situation, you're what we use in the legal term half pregnant. If the source just gives you the information, you're free to use it. You know that if you broke into the court and got the information, you can't use it. Here, if you're asking the source to break the law, you're dancing on thin ice. So you don't want to ask somebody to give you records. You can play the sympathetic character. Gee, I need something to support this. My editor won't let me run this without some documents. You're not asking them to do anything. And if they then give you documents, you're okay. But you can't ask them to get you documents that break the law. So similarly, and we see this all the time, both on court records. Back in the old days when you went to the courthouse and looked at court records, and today when they're online, you'll sometimes get your hands on a document that is sealed, that you shouldn't get your hands on. If the clerk gives it to you back in the old days, or if the clerk has the wrong security setting on it and you see it, you're welcome to use that. Again, as long as you haven't broken the law, and you haven't, you've simply gotten the information and used it. But you can't ask your source at the clerk's office to get you something that that is under seal, that they have to break the law to get. So remember, rule number 1, you can't break the law. If somebody else wants to break the law, that's their problem. You may get a subpoena, you may get called before the grand jury to identify where you got this, and then we get into the confidential source issue and what your promises are. You can see this all becomes a vicious circle. But those are all very good questions. So
another question real quick that I think is pertinent to this crowd. This comes from Nomin Ujiyadeen. She is asking, it's a records law that applies to those of us who work at public universities. For example, I work at UMKC. I have a personal cell phone that I pay for, not my employer, but I use it for work purposes regularly. I have work emails, Slack, etc. on my phone. Could my phone be subject to public records requests?
Yes, this is a fascinating issue. that is obviously unique to what you all do. I will tell you that I'm not picking on public radio people in particular, but I will tell you that journalists as a whole, in my experience, are the world's largest hypocrites. They want to go get information, but when people want information from them, it's like, oh no, oh no, oh no. I remember I had a TV station client who at the time was very big into doing undercover investigations, hard-hitting news. And the local alternative weekly newspaper showed up at their station one day with a big bouquet of balloons for the news director's birthday. And all they simply wanted to do was turn the table on the TV station of what the TV station did every day. And the news director came down to get the balloons, and they, said who they were and what they were for. And she just got furious. And it's like, okay, but this is what we do every day to people. Get used to it, folks. So we're very big open records proponents. So we need to understand that as employees of the university, as most of you are in fact subject to the public records law. I've given a lot of thought to this issue, and again, every state public records law are different in every state. But yes, on its face, as an employee of the university, which is in virtually every state subject to a state open records law, what you have, even on your personal phone, if you're using it for what you get paid to do, i.e. where you get your paycheck from, it is subject to the open records law. Now, different states have different exceptions to the open records law. Just to give you two, for example, in Kansas, there's an exception for privileged materials. So if we got that kind of request, we would argue that it's covered by the reporter's privilege. Kansas happens to have a statutory reporter's privilege. Missouri does not. Missouri also does not have that exception. Missouri does have an exception for records which were otherwise exempt by law. We would make an argument that the law in this instance is the First Amendment. But this is a fundamental issue, and we are, I had an entire team of folks who do what I do, and we're drilling down into this because this is an issue that I don't think, sure, we can't be the first people that have had this issue before, and we're drilling down into this to find a more creative solution, because clearly on its face it seems wrong, because it simply defies the whole idea of any type of reporter's privilege. So I mean, you've raised a fascinating issue. We could spend a whole entire hour and a half on it. And again, when I get to the third part of the hour is who I don't recall whoever used to say that. One of the things we're going to talk about are notes, and you've clearly raised a serious issue there. I'm not trying to avoid you, but I do want to move on, and we'll regroup with that, and then you've prompted us to continue work on this very important issue. Once you've gathered the news, you've got to report the news. But you have three things to worry about: being sued for defamation, being sued for invasion of privacy, being sued for other things, which are most likely what we call intellectual property, which is just a fancy word for copyrights, trademarks, and patents. Defamation is what we ordinarily think of as our biggest risk. Defamation is a false statement of fact of or concerning the plaintiff, made with the requisite degree of fault, which is the big deal, that causes damage to someone's reputation. So first of all, it has to be false. You've undoubtedly heard the statement that truth is a defense. No, truth is not a defense. Another reason people hate lawyers. I'm dancing on a pinhead. Truth as a defense suggests we have the burden of proving truth. We don't. The party suing us has the burden of proving falsity. And in some cases, that's the make or break issue. So it has to be false. Has to be a statement of fact. Steve Vachrod is ugly. Okay, well, is that a statement of fact or is that a statement of opinion? Here's the test. Can I objectively prove he's ugly? Steve Vachrod is stupid. Can I objectively prove he's stupid? I don't know what stupid is. Steve Vachrod is a convicted sex offender. Oh, okay. That one I can tell. I can go look it up in the books. He's either been convicted or not convicted. That's an objective fact. There's a case in Missouri that I handled, the Missouri Supreme Court. The Humane Society of the United States published a report called Missouri's Dirty Dozen, 12 of the worst puppy mills in the state of Missouri. And we got sued. Shockingly, the only one of the 12 who sued was run by the mother of the Republican leader of the Missouri House of Representatives. What a remarkable coincidence. My statement was, I don't know what dirty dozen means. And by the way, there were 14 in the report. I mean, if that doesn't demonstrate that it's not an objective fact, I don't know what is. I don't know what dirty means. 12 of the worst, I don't know what worst or better is. My chief example was one of the 14 had very, very few animal welfare citations, had been cited very infrequently by the federal and state animal welfare authorities. Yet in its application to do business, it described its method of euthanization as, quote, club the animal to death. I think most people would think that's worst. But it's clearly a subjective statement of opinion, what's better or what's worse. If we had said the 12 puppy mills with the most violations, that's an objective fact. We can get them, we can count them up, and we can put them in order. And if we got it wrong, we got it wrong. That's a false statement of fact. So the test is, can you objectively prove it true or false? And it doesn't have to be literally true, by the way. We have a concept that we call gist or sting. As long as the gist or sting of what we said is true, we may get the facts slightly wrong. Classic example is there's a case in which someone was reported to have stolen $1,000 of jewelry and they only stole $500 worth of jewelry. I don't care. They're thieves. Whether they're big thieves or little thieves, they're thieves. So the gist or sting is what's important. Has to be a false statement of fact that is about the plaintiff. Now, I'm sure you've all watched every minute of the Johnny Depp Amber Heard case. I did not. The op-ed that Amber Heard wrote never refers to Johnny Depp by name. It does not have to. The law uses the term of or concerning the plaintiff. And it's clear that she was referring to her ex-husband. So she was able to prevail even without using Johnny Depp's name. When I do pre-publication review of a story, one of the things I'm looking at is, are we talking about people who aren't identified by name? Because it's those people, you know, the subject of the story you've given a lot of attention to. You've probably got that right. Otherwise, the story wouldn't be at the point where it gets to me. But you undoubtedly didn't do the same level of work on some minor character. Maybe so minor they're not even mentioned by name. But if it's of and concerning them, they have a potential claim. Distinguish that. Again, I don't expect you to remember all these answers. I've been doing this for 40 years, and there are times I got to look it up. But distinguish of and concerning from what we call group libel. If you said, my law firm is named Lathrop GPM, all those lawyers, every lawyer at Lathrop GPM is a crook. Have you defamed me? Well, I'm a lawyer here. No, you haven't, because there are, I don't know, 300 lawyers here. You haven't named me. It's called group libel. So, again, these are fine distinctions. I don't expect you to remember them. But what I do want you to remember is think about everybody in your report, not just the main subject. Everybody in your report has a potential claim, whether they're named or not. False statement of fact of or concerning the plaintiff made with the requisite degree of fault. What is that mouthful? Well, what it means is that if you are doing a story about Joe Blow, a nobody, your neighbor who no one knows, then the test is what we call negligence. Did you act like a normal reporter in a similar situation would do? It's no different than, I go back to my example of a car crash. If you're busy looking at your phone and you crash into me in the car, you are negligent. You were not obeying the typical standard of care. I shouldn't say typical because everybody looks at their phone. It's not typical to crash into people. That's not what we want people to do. So if you put together a story that another reporter would say, what were they thinking? That's negligence. That applies to the Joe Blow, someone who's not what we call either a public official or a public figure. What are those? A public official is simple. The President of the United States, the governor, the mayor, the chief of police, probably a police officer, clearly a police sergeant, probably a police officer, clearly the superintendent of schools, probably a teacher, most likely a principal. These are what their name says, public officials, people who set public policy. Those people, under a case called New York Times v. Sullivan, have to prove not negligence, but a much higher standard of what we call actual malice. A terrible name and has nothing to do with what we think of, which is malice, which is ill will, hatred, spite. I want to get you. Actual malice is either I knew what I was saying was not true, but I didn't care, or I acted with what's called reckless disregard for whether it's true or not. It might have been made up, but I don't care. It was interesting. I'll give you what I believe is the quintessential example of reckless disregard. Again, it goes back to some radio morning shock jocks. Those people, by the way, are the worst thing for media law ever. This was what we used to call rip and read back in the old days, when you'd have a teletype and you'd rip off the Associated Press and you'd read it on air, called rip and read. Now you just look it up on the internet, but we still call it rip and read. This was one shock jock. It was a male and female shock jock team. And they were reading a story online about a teacher in California who during the day was a teacher, but at night was a porn star. And they said, I bet we have people like that in Kansas City. If you know of someone in Kansas City who leads a double life like that, let us know. So half an hour later in the show, the male disc jockey says, oh my gosh, I just got this text. I can't believe it. And I don't remember the person's real name. We'll call her Jane Doe. She went to Shawnee Mission West, which is, like people in St. Louis only care about where you went to high school. This is like, somehow this is going to be relevant that she went to Shawnee Mission West. And then he starts this very, again, as shock jocks do, very dramatic. I can't look at these. I can't. She's doing what? Oh, I can't look at this. The female, and he uses her name. The female shock jock says, now we don't know if this is true or not. This is just what the text says. Okay. Is that the definition of, I don't know if it's true or not? Reckless disregard. It's entertaining. I don't know if it's true or not. And the woman sued, and shockingly, got $1 million because she could establish actual malice. So it's very difficult to establish actual malice against most reporters because most reporters are not like that. The New York Times defended the Sarah Palin case, in which their editorial clearly got it wrong. Sarah Palin was not behind this ad that put sharpshooter targets over individuals. The author of the editorial thought she was. It was just a mistake. And the court defended that. The New York Times defended that on the grounds of actual malice, and the court and the jury agreed. I tried a case in which a school principal, who's a public official, this was a TV station, which again happened to be the same sensationalism TV station I mentioned earlier. There was a story involving third graders at an elementary school that were strip searched for missing lunch money. The station did, I'm not exaggerating, 25 stories about it. The 26th story is what they call an anchor read. A producer wrote it and the anchor just read it. There's no real reporting in it. But the principal at the elementary school where the kids were strip searched is asking the school board to be allowed to resign rather than being fired tonight. We'll update you at 10. It wasn't the principal. The principal wasn't even in the building that day. It was just a mistake, a simple mistake. Was it negligent? Yes. Just like you paying attention to your phone and crashing into me is negligent, but it wasn't actual malice. She testified at trial. My producer testified at trial, happened to be 9 months pregnant, cried legitimately because she was so upset about it. And so I feel terrible. I made a mistake. I don't know what I was thinking. I knew better. It was just a mistake. The jury found no actual malice. So again, that's why it's very difficult for public officials to recover. We also have public figures who are covered by the same rule. So celebrities, Johnny Depp clearly would have to show actual malice. Now, in his case, he was able to show actual malice because his claim was that Amber made up the whole thing. She knew it wasn't true. That becomes a question for the jury to decide. The jury found in his favor, though the jury also found in her favor, so I don't really understand that whole issue. But actual malice is very difficult, and that's the greatest protection we have most of the time against defamation cases. So the number one thing I do when you send me something to do pre-publication review is identify who we're talking about and assess in my mind whether they're a public official or public figure. Because it's going to go a long way to how many questions I'm going to ask you about what you've done and how solid your information is. And also, we're also protected by what's called a privilege. So the law wants to encourage, this is a democracy. We vote on our leaders. We believe, rightly or wrongly, that an informed electorate is how we should govern ourselves. Well, we can't legitimately and validly vote on our officials if we don't know what our officials are doing. Therefore, we want to encourage more information to people about what our officials are doing. So we have what's called a qualified privilege. I can report on what's going on at the government level and not worry about being sued so long as I've fairly and accurately summarized what the government is doing. Well, a lot of what the government does happens in courts. So I can report on what's alleged in a lawsuit, what happens at trial, what's submitted in a affidavit in a lawsuit to a court record, because I'm reporting on the court. Now, my main reason for reporting may be because I want to report on some allegation against some person, but ultimately there's going to be some kind of resolution in the court, and the public's entitled to know whether the courts are corrupt, whether justice is being served. So we have a qualified privilege. That's why back in the day, everyone could report that O.J. Simpson killed these people, even though he was acquitted, because we're reporting on what the allegation was in the lawsuit. So as a result, that's one thing that, again, in doing pre-publication, I clearly look at. If you come to me with a story that has serious allegations, but those are all backed up in court pleadings, in court documents, in court testimony, I'm much more likely to give you the green light than if you just come and tell me, oh, this is what my sources told me. And oh, by the way, I promised my source confidentiality. You're going to have a much tougher time getting that past me. That's the essence of defamation. We could talk about this all day, and that's what I do for a living. But let's move on quickly to invasion of privacy. Again, we told you there's four types of invasion of privacy. We talked about intrusion upon seclusion. There's false light invasion of privacy, publication of private facts, misappropriation of name or likeness. Publication of private facts. There are certain facts which are private. So if I wanted to report on my neighbor's sex life, probably not newsworthy. Again, my neighbor, he sells pharmaceuticals and she's a personal trainer. I don't know what their sex life has to do anything. If I want to report on the sex life of the governor, well, that I think is newsworthy. So it's a very slippery slope. The whole invasion of privacy thing is scary. But the question is the information newsworthy? Again, we're public radio. We don't engage in a lot of sensationalism. You have an editor who helps you make these decisions. So it's generally not a real issue on publication of private facts. But let's say that you received, again, you didn't ask for it. Well, let's go better. Let's say the New York Times gets Donald Trump's tax returns. Tax returns are clearly something private. You can't Google them and get them. If those were the tax returns of a nobody, the New York Times publishing those would be publishing a private fact. The tax returns of Donald Trump are clearly not a private fact. They are clearly newsworthy. So the Times is entitled to publish those without fear of liability of publication of private facts. Misappropriation of name or likeness, well, that generally doesn't apply to us. That is, if I say that you should buy this football because Patrick Mahomes uses this, I'm appropriating his name, his likeness, his picture to sell a product. We don't generally do that, so that's generally not an issue. Then there's something we call false light, which is the scariest thing known to mankind. False light is defined differently in every state. Essentially, it's defamation light, defamation without damage to reputation. Because it's dangerous, it generally has the same defenses as defamation. So I'll worry about it. You don't need to worry about it. If you're doing your otherwise job and we're not worried about defamation, we're probably not worried about false light. The other things we need to worry about in what we say about getting sued is what we call intellectual property. Hold still 1 second. Generally, copyright, trademarks, and patent. Copyright, as we all know, is you can't plagiarize. I mean, first of all, it's unethical to plagiarize, but it's much more complicated than that. You've undoubtedly seen on things a C and a circle. What does that mean? For your purposes, absolutely nothing. Because, and this will come as a shock to almost anybody, the C and the circle doesn't mean anything because you have a copyright in everything that is what we call fixed. So, for example, I took these notes this morning in a doctor call. Are these copyrighted? Absolutely. They're fixed. They're recorded in ink on a piece of paper. If I say la 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 la, is that copyrighted? Interestingly enough, it is, because I had to consent to this being recorded. So it's sitting on some computer server somewhere. I don't have to go register with the Copyright Office. I don't have to get the C in the circle and all that stuff. It's copyrighted the minute it's fixed. Anything is recorded, whether it's on a piece of paper. So if I sit here, but I'll use my home computer. I'm on my home computer and I type a letter and I do not hit save and I do not have auto save on and I don't print it. Is it fixed? No. The minute I save it, because it can go away, the minute I save it, it's fixed. The minute I print it, it's fixed. I'm giving you all of this gobbledygook for one reason. If it's on the internet, almost certain it's fixed because it's sitting on some computer server somewhere. That's how you accessed it. You did a Google search and you got a hit, which is taking you to some computer server, which means it's fixed, which means it's copyrighted, which means you can't use it either without permission or with what we call fair use. So you can't illustrate your online report with a photo you found online thinking, oh, it's online. It's not copyrighted. No, it is copyrighted. Now, let's say you're doing a story on me and you go to my law firm's website and you take my picture and you post it as part of your report. Have you taken someone's copyrighted photo? Yes. By the way, I don't own that copyright. Either the photographer who took it, or because we're a fancy law firm, we probably have a license agreement that we own the copyright. So you've taken a copyrighted photo and you're using it. However, for the news business, our biggest way we can do this is what we call fair use. You're not using it because you want to set up a competing law firm and you want to say that Bernie Rhodes is our chief lawyer. You're using it because you're reporting on me, you're commenting on me. The classic fair use example is a book review. I'm doing a book review or a movie review if I'm a TV station or a radio station, and I use a clip. I mean, we all know the movie's copyrighted, but the clip is, how are we going to back up our statement that this is the world's worst movie unless we show a clip showing how stupid the movie is? So that's what we call fair use. So, you'll hear different things that, 30 seconds is okay. There is no per se rule. My favorite case is called Zucchini versus Scripps Howard. Back in the old days at the circus, they'd have human cannonballs. A person who would literally be shot out of a cannon across the 3 rings and land in a net. It was shown on a local TV station. The circus sued, saying, you've taken everything I have of value because people are not going to come now. So even though it didn't last, I assure you, 30 seconds, so there is no per se rule. If you were to take my law firm's entire website and post it on yours, that's clearly going beyond the fair use. You're not using it to illustrate your story about me. You're stealing my entire content. If to do your movie review, you downloaded the entire movie and posted it online, that's not fair use. That's taking the entire movie and infringing it. Again, there are no rules. This is all very complicated, but it's things to think about. The next biggest thing is what we call trademark. Trademark is the identification of source. My law firm is named Lathrop GPM. That is a trademark. When people think Lathrop GPM, they think, oh, that's Bernie's firm. McDonald's, when we see the golden arches, we think that's McDonald's. We identify it as the source. We either want to eat at McDonald's or we don't want to eat at McDonald's, but we know what it's like when we see the Golden Arches. We know what the food is like. We know we either like it or we don't like it. Whereas we show up in a small town and we see some diner called Joe's Diner, we don't know what it's like. Could be the greatest food, could be the worst food. We don't know. Again, yeah, you'll see these little symbols. I see Dan Margulies has joined us. He could not answer this question because that would not be fair. But you'll see an R in a circle. If you know what the R in the circle is, it means it's a registered trademark. Who cares? You'll see a K in a circle. You know what that means? It's kosher. Who cares? Ignore those things. They're not important. Just like the C in the circle is not important.
care.
The R in the circle is not important. The TM, you'll see TM. It doesn't matter. Trademarks are trademarks. If you go to my law firm, I'm looking at my home screen. It says Lathrop GPM. There's no R in a circle. There's no TM. There's no trademark. There's no nothing. It's a trademark. We generally don't have to worry about that in our reporting because our reporting is fair use. How do you describe me as a lawyer at Lathrop GPM without using the term Lathrop GPM? I once got a claim, as Steve said, I do work all over the country. I once got a claim from the University of Georgia Athletic Department because my TV station had the dog, DAWG show on after University of Georgia football games. And they got a, we got a claim that we were violating their trademark. And I said, what do you want to call us? The show about the dog who raises his legs and urinates on the fire hydrant every time he goes by show? The dog show is defining what the show is about. So that's a fair use. Where you need to worry about trademark is if you're naming a program. That's where you need to be concerned because you may be infringing on someone else's name. So that's the biggest concern about trademark. Patents, they don't come up in reporting. A patent is, I have a right in a method of production. The famous Amazon one-click, that's a patent. So reporting, we don't have to worry about it. Behind the scenes, we sometimes do. On websites, for example, believe me, there's so many patent claims on, scrolling and all this stuff on the internet. It's out of control. But for what you do, you generally don't have to worry about it. So now you've gathered the news. Now you've reported the news. Now what happens? Again, I think, and personally, this is the biggest. Steve, do you have a question?
I was just going to answer it, but I'll let you go on. I know where you're going.
Okay. This, in my mind, is the biggest takeaway I want you to take. Once you've done the report, this is how you can best avoid being sued. Again, you're all good reporters or you wouldn't be where you are. You're all careful or you wouldn't be where you are. You've got editors. We do what we can to get things right. Well, we're not the good housekeeping seal of approval. We sometimes make mistakes. I belong to this group of total nerds called the Media Law Resource Center. It's people like me all over who do what I do all over the country. We have found, without a doubt, the number one way to get sued is to ignore somebody who calls and complains about your report. I know it's not comfortable dealing with people who want to gripe at you, and you don't have to. That's what you have an editor for. Send them upstairs. But you have to deal with these people. You have to give them an opportunity to vent. I'm not saying you have to make a correction. I'm not saying you have to clarify anything. I'm not saying you have to admit you did anything wrong. You may not. But you have to give them an opportunity to vent, because if you don't, they're going to feel emasculated, and that the only way to restore their virility is to go hire a lawyer. I can't tell you how many times, I can give you an example. The principal case that I told you about earlier, the elementary school principal, who we got wrong. We flat got wrong. She called the station, asked for the general manager, or was directed to the general manager, left a message. The general manager, not wanting to be involved in a confrontation, forwarded the message to the news director. The news director was new, said, not my problem. No one ever called her back. Guess what? She sued. Had someone talked to her, we would have immediately said, oh, crap, we got this wrong. We would have corrected it. Would she have sued? Highly unlikely. But we never did. So you've got to confront people who are griping. I'm not talking about a request for a retraction. Some states, Nebraska and Iowa, for example, have what we call retraction statutes. They're very specific. They deal with someone calling up saying, you got it wrong, I want you to retract it. We have so many days to do so. If we don't, something happens. If we do, something else happens. I'm not talking about all that. I'm talking about the very common sense idea that, I mean, you know what it's like when your boss ignores you. It's the same thing here. Or when your spouse ignores you, your partner ignores you. It's the same thing here. You have to give these people a chance to vent. Listen to them. You may well find out you made a mistake. We're all human. If you didn't make a mistake, okay, don't argue with them. That's why I say, send them upstairs to your editor. That's a great way, in my experience, to diffuse things. If that doesn't work and we get in a lawsuit, then the question is going to come up. We're back to Nomin's idea. What about our notes? What about our Slack messages? There is no easy answer. As with so much, there is no easy answer. Well, there is an easy answer. If in every story you did, you had perfectly typed notes that are 100% accurate, that include 100% of every conversation you had, which are not disparaging in any way, then keep your notes. That never happens, by the way. But if you throw away all of your notes, then the argument is, well, did you do any work? There is no easy answer here. This is truly there's no answer. I mean, I will tell you, I have seen thousands, literally thousands of notes. Some of them have the Chinese takeout order on them. Some of them have the Chinese food spilled on them. My favorite set of notes ever is a reporter who I asked her to, we got sued. I asked her to send me my notes. I opened up the envelope. It was a styrofoam paper plate, because she was at home when she got the call. That's all she had to write on. And she had literally taken the rim of the styrofoam and torn it into little pieces so it fit flat in the FedEx envelope to send me. There is no right or wrong answer as to whether to keep notes. Anybody who tells you they have a policy, I'd be concerned what that policy is, because it's not always a good one. Generally speaking, if it's a longer piece, it's probably better to have notes to show how thorough you were. If it's a shorter piece, it's probably not good to have notes. But the last thing you want to do is start getting rid of notes once you get some kind of word that there's a problem. Those of you who may recall Martha Stewart going to jail, she did not go to jail for insider trading. She went to jail for trying to hide the fact that she committed insider trading. There's something called obstruction of justice. In the legal business, we have something fancy term we call spoliation of evidence. If you start destroying evidence after you know of a potential claim, then the idea is you must be destroying it because it's bad for you. And therefore the judge tells the jury, you can assume that because these documents were destroyed, that they were bad. Well, that's never good for us. So we don't want those kind of things out there. So it goes back to, when creating your notes, think about your mother. Would your mother be proud of you in reading these notes? Do you refer to the subject of the story as with a bad name? Are there disparaging comments? These are all things that are going to be blown up 6 foot large in front of a jury. I'm not exaggerating. Those jurors are going to be like your mother. Would your mother be proud of these notes? If not, do a better job taking notes. It's too late after the fact to try to correct the notes. So think about what you're doing while you're taking the notes. Do you keep them? That's again, unless you have a policy in which I'll want to talk to the people in charge, it's up to you. But again, don't have one policy for when you think you're going to get sued, and another policy when you don't. That's going to get you in worse trouble. So, Steve, go ahead. What questions have we got?
Okay, to square a circle a little bit from Nomeen's earlier question, she followed up with, and this is again the idea that her personal cell phone could be subject
Sure.
to a public records request, but what parts of my phone could be subject to public records request? Just my work emails and other work-related communications, or my texts with my mom, vacation photos, personal Instagram account, etc.?
Well, that one I can feel fairly confident saying only the work-related matters.
Okay.
So I'm not suggesting that you go out and get two different phones because with under the open records, whether we call it the Sunshine Law, the Public Records Law, the Federal Freedom of Information Law, they're all the same thing. There's no right to access the device. If we get in a lawsuit, that's a different issue, but there's no right to access the device. There's only the obligation to produce files maintained by the university. And if you're doing university work, so then those things would be subject, but the other things wouldn't. If you want to send me the vacation photos, I'm happy to look at them, but.
I had a question, and I'll get to one of Dan's here in a second, but one of the things that we run into as journalists is a lot of us have Twitter accounts. We have Facebook pages as journalists, things that we use to disseminate the news, and it's often unsupervised. I do not read reporters' text messages, or not text messages, their Twitter messages before they go out. What is your advice on how to use social media in connection with the work that you're doing?
I'll be sarcastic and say I have no advice on how to use social media, because social media is no different than what you put on the radio or you put online. So everything I have told you applies to social media. It's a great question. There is no social media exception to defamation. There's no social media exception to invasion of privacy or intellectual property. All of the rules that we have that I've discussed with you are the same rules that apply to social media. You can defame someone in a tweet. You can. I've got a case right now. Literally, I'm defending a case. It could be one of the silliest cases. Well, I have a lot of silly cases, so I don't want to say that. I am defending a woman who, when you print off the screenshots, wrote a 10-page Facebook review of a business, and she's been sued for defamation. The fact that it's Facebook is utterly irrelevant. She could have written the same thing as a letter to the editor of the newspaper. She could have owned a newspaper and said the exact same thing. So the fact that it's on Facebook is utterly irrelevant to the application of the law. So everything I've told you applies equally to Facebook, Twitter, Instagram, any social media platform. What else?
Let's see. Dan Margulies is wondering, what are the odds
what the K in the circle is? He knows.
He does know. But what he doesn't know, and what he wants you to give a sense of, is what are the odds that the Supreme Court of the United States will relax the actual malice standard, given that some of the justices have expressed skepticism about Times versus Sullivan?
Very interesting. So I think I mentioned New York Times versus Sullivan is the case which held that public officials have to prove actual malice. Subsequently, the Supreme Court extended the actual malice requirement to public officials. So to answer the precise question, do I think what's likely the Supreme Court will change the public official actual malice rule? I don't think that's very likely. A lot of people are talking in my circles, again, these nerds that I hang out with at the MLRC, we talk about this all the time, the Sarah Palin case. Since she lost on actual malice, is she going to take that to the Supreme Court? And are they going to change the rules for people like Sarah Palin? I don't think so. I don't, to answer the precise question, what are the chances? I don't think they're very high. I think what's higher is that the court may relax the rule for public figures, celebrities, athletes, people who are not in charge of our government, but just folks who have a lot of high profiles. I think it's much more likely that the court would look at those people and reduce the protection of the actual malice rule. Again, if you would ask me, I would have never thought the court would reverse Roe v. Wade, particularly after what these recent justices claimed in their confirmation process. But it appears, knock on wood, it appears that I'm wrong there. So don't rely on what I think is going to happen to the Supreme Court. But I'd be very surprised. Of course, I'm surprised if they really do overturn Roe, but I would be surprised if they overturn actual malice as to public officials.
Another question in the chat, and if you guys, we have 9 minutes to go, so if you guys have questions, hit us up. We'll get them to Bernie. Bernie, do you have a quick, this is from Holly, do you have a favorite quick reference online that reporters can use to refer to things like libel, privacy, etc.? Any kind of...
No. The short answer is no. But I would recommend the Reporters Committee for Freedom of the Press for things like shield laws, for things like they have a great 50-state survey of one-party, two-party consent. Libel law and defamation law is so all over the place. No, I mean the RCFP have some information. You can go there. They're one of my favorite places. So as a shortcut, I'd go there.
I have a question for you. Can you talk about this middle ground between a public figure, public official, and private citizen, which is this limited purpose public official? If
Very
I've got
good.
the term
Very good.
right.
Very good. So I've got a case right now. Okay, so we all know what a public official is. A principal of an elementary school is. By the way, a janitor at a public school is probably not. And I'm not picking on janitors, but I'm specifically drawing a distinction between people who set policy and people who don't. So a janitor at a public school is probably not. A principal is. By the way, a principal at a private school is not a public official. Then there's a public figure, somebody who's well known. Then we do have this middle ground, as Steve very accurately points out, called a limited purpose public figure. It's someone who's not well known in general, but on a particular topic is well known. So I have a case right now in which I'm defending a TV station in a lawsuit brought by a lawyer who claims that she was defamed by the TV station's report of a lawsuit against her. Well, the lawsuit against her is actually brought by an Indian tribe, and it relates to the lawyer claims she was only sued because she's been very vocal and advocate in opposing things that the tribe is doing about a settlement of another lawsuit. And I'm arguing she's a limited purpose public figure. I mean, the whole reason she claims she was sued by the tribe is because of her public advocacy, that she's known as somebody opposing the tribe, and she claims the tribe is retaliating against her because of that. Well, that's someone who has thrust themselves into the middle of a controversy. She's known for being that. I mean, she even claims that one of the candidates for office of the tribe sent out a mailer opposing her. Well, that's a limited purpose public figure. If I told her your name, you would never in 100 years have heard of her. She's clearly not a celebrity. She's clearly not well known. She's clearly not a public figure, but she's, in my argument, a limited purpose public figure for this very specific purpose. People know her and know what she stands for, as evidenced by the fact she claims that's why she got sued. So, very good question, Steve. Again, so when I do a pre-publication review, as I mentioned, one of the things I do is I look at, are they a public figure? Are they a public figure? Are they a limited purpose public figure? Because and often they are, because if we're doing a story on them, then it's most likely something of newsworthy matter. Sometimes we reach out to things that aren't otherwise in the public eye, but a lot of what we do is already in the public eye. And so as a result, if somebody's involved in that, there may be a good argument they're a limited purpose public figure. So excellent question.
So like somebody like a lobbyist,
not as good as Domeen's question, which still I don't have a good answer for.
Right. So is somebody like a lobbyist who's trying to influence public affairs, not generally known to the...
A good example. Yes, exactly. It's a very good example.
And Bernie, if I can chime in here and ask you a follow-up question on that particular case involving the limited purpose public figure. If the station in question, the defendant, accurately reported what was in that lawsuit, didn't it have also a qualified privilege at the very least to do that report?
The allegation is we got it wrong.
I see. Okay.
Correct. Very, very good. He wasn't even here, ladies and gentlemen, for the qualified privilege discussion. The allegation is we got it wrong.
Okay. Can I jump in and ask a very quick question? We often lift photographs from Facebook. What is the propriety of that?
Well, again, everybody, if you got it from Facebook, is it fixed? Yes. Sitting on Facebook's server. So it's copyrighted. If you're, therefore we rely on the fair use defense. If you're taking the picture off Facebook simply because you're too lazy, not being sarcastic, to go take a photo of the person, then it's arguably not fair use. You're just too lazy. That's why what you'll see oftentimes, particularly with my clients, is what we call framing. If I'm doing a story about Dan Margulies and there's something on his Facebook page that's relevant to the story, then I won't just literally right click and save his photo. I'll do a screenshot that frames it, that it's clear that it's from Facebook. It might have a Facebook post or something, because now I'm commenting on his Facebook post, not just stealing his photograph. So again, chances are, how many people are going to, by the way, this photograph on someone's Facebook page, unless it's a selfie, the person who has the Facebook page, they don't own the copyright. The copyright is owned by whoever took the photo. So the chance of someone actually suing is small, but we like to not violate the law even without getting sued. The whole idea of again, I told you that the same law applies to Facebook, Twitter, social media. This is the one area in which the law hasn't really caught up, because we are admittedly sometimes stretching the definition of fair use in order to do what we all do every day.
Well, there's no more questions in the chat, and we're at 11:59. So we're pretty much out of time. But Bernie,
damn, I had one more question for Bernie. Can we give us 2 minutes? It involves a case that I think Bernie was the attorney on, and this concerns invasion of privacy, and that was that crazy Channel 5 case in which some scavenger picked up a computer that a plastic surgeon had left on the sidewalk that contained before and after photographs. Channel 5 reported on it, ostensibly pointing out the danger of just throwing out your computer willy-nilly without erasing whatever is on it. But some of the people who were in those before and after photos sued, right, on the grounds of invasion of privacy. How does that relate to what you were talking about, Bernie?
Well, first of all, none of the patients sued, the doctor sued.
Oh, it was the doctor.
Uh,
That's right.
yeah, the
Bortnick.
doctor
Right.
sued.
Right. Yeah.
And the answer to that was, this was, by the way, these were before and after pictures of breast surgery.
Yeah.
And so what we did, it's a television station, so we had FCC obscenity rules. Obviously, we did not show individuals' breast, but obviously we also did not identify, we didn't show people's faces. So we used enough of the photo to demonstrate what had occurred without either violating the obscenity rules or without invading their privacy, for the very reason that Dan correctly points out. That would be, if you go back to what I said, that would be a classic publication of private facts. When the patient submitted to having before and after taken photos, she, because these were all breast surgery patients, never consented to them being posted to the web or put on TV.
But what was the doctor suing over?
The doctor was suing, claiming the privacy rights of the patients.
Oh,
Yeah, he had no privacy rights in his computer once he set it out on the curb.
right. So what was the outcome? I know the outcome, but you might want to tell everybody.
We broadcast the report, and the doctor dismissed his lawsuit. Again, as Steve said, my job is to help you get you things on the air, not to tell you what you can't do.
Well, thank you so much. This has been really great, and we did record it. So even though people can't memorize everything you said, Bernie, they will be able to replay it, add in
Good.
time. So thank you, and we will see you, Bernie, shortly, if only in cyberspace, for another script read.
Sure, I'm available. Thank you.
Thanks.
Good luck, everybody.
Thanks, Steve.
Thanks, Bernie.
Bye-bye.